This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Okay, I'm going to start this lecture in the same way that I promised you I will start them all, although to a lesser degree, what I'm about to say is of less relevance or less importance in this particular section of partnership law. But what I'm about to say is you do not need to know or remember the names of cases that I quote to you. You don't need to remember the names of legislation, of pieces of statute. You don't need to know that it's the Limited Partnerships Act of 1907. There's no need to remember section numbers of acts nor the years of acts. So just do not clutter your mind with that irrelevant nonsense. Okay, so I want to move on now to partnership. And really, before I start, I want to get one or two basic things straight with you so that we can then move on in full understanding, full knowledge. And really what I want to say is this, that a partnership is not like a company, not like a limited company. We will find out about limited companies in the very near future, but a company in law is a separate person. It exists in its own right. It can do all sorts of things. It can sue and be sued. It can own its own property. It can borrow money in its own name. But a partnership is not the same. A partnership is really just a collection of sole traders who decided to get together for a common purpose. So a partnership does not exist in its own right. So if you have a partnership of two and one dies, so make it easier, a partnership of three and one dies, the other two don't continue like it would if you were a company. If you have a company with three members and one of those members dies or sells their shares, the company continues as a legal entity. But in a partnership of three, if one dies, that's it, the partnership dies. So partnerships are not separate people in law. And the second thing I want to emphasize before we get too further is that partnerships can do anything at all so long as it's legal. A partnership can be created to do anything so long as it's legal. And if we can agree on what we're going to do as a partnership, you and I, if we can agree what we shall do as a partnership, that's fine. And we can do that straight away. And there's no formalities involved, or there needn't be any formalities. Just you and I agreeing, like we are doing now, that we shall form a partnership to do the buying and selling of used cars. But having agreed that, we're equally in the position where we can agree to change the rules of the partnership. So partnership is formed by agreement, and therefore it's also capable of alteration by agreement. So those are basic premises that we need to start off with before I get into the notes. But here are the notes, and you'll see straight away that I've written something already here against the case Everton-Williams. Everett seems to have a variety of spellings, Everett or Everett. It's a 1700 and something case, so in those days people were not so particular about spelling and consistency of spelling. Shakespeare's signature, Shakespeare's name appears in his handwriting 6 times, and in 4 of those the spelling is different. So there's only 3 where the spelling is the same, and the other 3, it's 3 different spellings again compared with that 4th one. So in times gone by, spelling did not appear to be quite such an apparently important characteristic. So let's have a look at this definition first of all. A partnership is defined as the relationship that subsists between 2 or more people carrying on business in common. It doesn't say anything about it being in writing. It doesn't say anything about it being committed to paper and being stamped and sealed and authorized and sanctioned and registered. No, it doesn't say that. It just says a partnership is the relationship that subsists between 2 or more people carrying on business in common. What is important, that incidentally is a definition from the 1890 Act, but again, you don't need to remember that fact. What is important is the elements within that definition. So it's a relationship that subsists between two or more. Well, clearly you can't have a partnership of one. You can have a company where there's only one member. You can have a company where there's only one director. But you can't have a partnership of one. There have to be two or more. There is an upper limit, which we'll come to. I'll tell you now. There is an upper limit for firms of, excluding firms like accountants, solicitors, members of the stock exchange, where there is no limit. And in addition, estate agents, estate managers, consulting engineers, architects, building designers, building planners, that type of profession, they are exempt from this upper limit, provided, as a general rule, provided at least 75% of their partners are members of an appropriate professional organisation. So a member of the National Association of Estate Agents or Royal Institute of British Architects, something like that. So long as a general rule, you don't need to get into the minutiae, but as a general rule, so long as 75% of their partners are members of an appropriate professional organisation. Otherwise, if it's not accountants, solicitors, members of the stock exchange, if it's not estate agents, estate managers, building designers, consult, and so on, then there is an upper limit of 20. So a partnership of people who want to create a firm, an association, where they are selling furniture, then you can't have more than 20 partners. So it subsists between two or more people, clearly. Carrying on, this is an ongoing activity. This is not something that has happened in the past. It's not something which is a one-off. It's not something which they intend to do in the future. It is a business that is being carried on. So that part of the definition is important. Business in common, carrying on business in common. So you as a car salesman and me as a furniture manufacturer, that's not business in common. So that would not rank as a partnership. With a view to profit. Now, you can't legislate and make partnerships make a profit. All you can do is say, this is the relationship that subsists between two or more people carrying on business in common with the intention of, we're trying to make a profit. We may not be very successful, it may be a disaster. But if we're aiming to make a profit, then that part of the definition will be satisfied. So that's what a partnership is. It must be, much of present-day partnership is in the Partnership Act. It's here. Business must be being carried on. It must be with a view to profit. And if the relationship between two or more people satisfies this definition, then even though they themselves may not have considered themselves to be in partnership, on application to the court may say, this relationship that you have sounds to me like a partnership, and so a partnership would be deemed to exist. Doesn't have to be in writing, doesn't have to be signed, sealed and delivered. We don't need any signatures. It doesn't even have to be an oral agreement. It's just that where two people carry on business in common as though they were in partnership, the court may deem that a partnership exists. We can agree amongst ourselves to do anything I want, so long as it's legal. And I've given you the case there, Everton Williams, but I've only given it to you because it's just such a fun case. I suggest, if you have a moment or two, I suggest that you put this link in http://mentalfloss.com/article/92239. I suggest you put that into your search engine because it's a dream of a case. It is so much fun. So try that. Okay, so we got through some of the basics now. If a business relationship does satisfy the definition, the courts may say, yeah, That's a partnership, even though you or I may not want it to be a partnership. We may even have said we are not in any sort of partnership. But if that relationship that between us does satisfy the definition, the court may say it's a partnership. As a general rule, partners in a firm are jointly and severally liable for the debts of the firm, for the partnership debts. So if you enter into a contract, and you and I are in partnership, if you enter into a contract in the partnership's name, then I become liable because it's now a partnership debt. Then I am equally liable for the partnership debts as you are. Not only equally liable, I'm not talking about profit shares here. I'm saying you enter into a contract in the partnership's name. It's now a partnership debt. You then declare yourself to be bankrupt. I am wholly liable for the debt that you have incurred on behalf of the partnership. So every partner is liable down to the value of their private estates for the entirety of the partnership debts. Then we get a little one or two bits of variabilities there. Every partner is an agent of the firm and the other partners for the purpose of the business of the firm. The acts of every partner done in the course of the firm's business bind the firm and the partners. The only exception is where a partner is acting beyond his authority and the person with whom he is dealing, she is dealing, was aware of that partner's excess over their authority, or they were not aware that that person was a partner in the first place. You can't hold a partnership firm liable if you deal with somebody not knowing that they are a partner. You can't later discover that they are a partner in a partnership and therefore try to sue the other partners. But remember that the acts of every partner done in the course of the firm's business bind the firm and the partners for the purpose of the business of the firm. Moving on, the agreement. Now, it's not so far been apparent in previous lectures, but I'm a person that remembers things by mnemonic. I find things become easier for me if I have a mnemonic that I can fall back on. And we have here the mnemonic ACCA. I've just been playing around with this. I was just looking as I was setting up the computer. I was thinking you could mnemonify this into corporate governance addicts. So you can add corporate governance addicts or add CIS. Add the Cooperative Insurance Society's capital gains tax is the way I remember it. It's easy because when I did my exams, they were the hall within which those exams were set was the Cooperative Insurance Society Hall, the CIS building in Manchester. But if you want to remember corporate governance addicts, that's fine. I'm going to use add CIS CGT. And this mnemonic is telling me typical contents of this agreement that partners will enter into. Ideally, it will be written. I've been screwed in the past by a former partner, and we didn't have a formal written agreement, and I should have done that. That was my stupidity. I trusted him. He was a former student, former work colleague, now obviously former partner as well. But because it wasn't in writing and I trusted him, then it fell apart and I got severely financially injured. So, write it down. I used to recommend to former clients, don't go into partnership unless you are 150% certain that you can trust the other person. It's a dangerous, dangerous path to tread. Typical matters to be agreed upon. Accounts and audit. Are the partnership accounts going to be, or who is going to maintain those partnership accounts? Is it going to be you or is it going to be me maintaining those books of account, those records? And are we going to subject them to audit? Now don't forget that you and I may have a third partner, a sleeping partner, a non-active partner, a person who doesn't get involved in the day-to-day running. It's not necessary for a partnership to be audited, for a partnership records to be audited, but as a sleeping partner, you may very well feel that it is in your interest to have those partnership figures audited. Because if you're not getting involved in the activities of the partnership, you really do not have any idea about what you and I are doing. This third person has no idea. So accounts and audit. Number two, there's division of profits. The profit sharing ratio, if you like. If I put in 90% of the capital and you put in 10% of the capital, if I do 95% of the work and you do 5% of the work, then we need to agree on a profit sharing ratio. But remember, we can agree anything. I had a partnership, a small accountancy partnership with my former wife, and I would do a full day's work at work and then come home and do the accountant's work while she was in the home looking after the children. So I did all the work. I set the firm up. She did a little bit of work being an accountant. She did a little bit of work. And then in order to maximize the potential of our tax allowances, because she'd had no formal work and no salary and no income, it made sense for her to take the bulk of the partnership profits, whereas I already had a good salary from working as an accountancy tutor, and so it didn't make sense for me to take a big share of the profits because I was already being taxed at maximum rate. So although I did the work, although I put in the capital to start the firm, start the business, although I did another full day's work, having done a full day's work accountancy tutoring, the profit share that we agreed was that she should get 99% and I should get 1%. And that's perfectly legal and it maximized the income for the family. And it was only after the breakup of the marriage that we broke the partnership up. So it didn't matter. At the time, it maximized the partnership income. We can do anything we want as long as it's legal. The division of profits should be agreed upon. This one, I'll write these down, accounts and audit. I'm sorry, I should have done, shouldn't I? Accounts and audit, division of profits. This one is drawings. You see, when partnerships make profits, the money is kept in a partnership bank account. Well, that's not good to me when I want to go out and buy some food. So I need to be, if I have no other income, I need something to be coming out of that partnership in order that I can afford to live. So I'm allowed to draw money out of the firm in advance of being credited with my share of the partnership profits. But there really ought to be a limit on this. So it may be a monthly limit, maybe a half-yearly limit, maybe an annual limit. But the amount by which a partner may draw in advance of being credited with their share of profits, we need to agree upon that. See, are we going to have a combined capital plus current account for each partner? Or are we just going to have a capital account separated from a current account? And in the capital account, we'll have the amount of capital that each of us has agreed to introduce, and that will be effectively fixed. It isn't fixed, but it will be effectively fixed because we've agreed that we will not draw out against it. The current account, within that, there will be things like interest on capital introduced. There will be a salary entitlement if we have agreed to pay a salary. There will be share of profits going in. And on the other side, on the debit side, we'll have the amounts drawn by each partner through the course of the year. So a current account to record the day-to-day activities of the partners within the firm, or with reference to the firm. Interest. That's an interesting one, pardon me. That's an interesting one because even though I put in our situation, if I put in $100,000 and you put in $10, then surely it's only fair that I should be given a preferential allocation of profits by way of interest on the excess capital that I have introduced into the firm. We need to agree this. Any interest which is to be payable needs to be agreed in advance. So interest on capital, and whether we're going to charge interest on overdrawn current accounts. If you have drawn out too much in advance of being credited with your share of profit, is the firm going to charge you with interest in order to compensate the other partners because they haven't overdrawn their current accounts? As is salaries, we need to agree. I am doing all the work. You're sitting at home resting. We need to agree. Am I to be compensated for all this extra effort that I'm putting into our firm or not? So this is something we can, don't forget, we can agree to do anything so long as it's legal. We can agree in the situation with me doing all the work and me putting in all the capital and you taking 99% of the profits. We can agree that not only do you get 99% of the profits, but in addition, out of this pot of profits, you're going to skim off an amount for salary. You're going to skim off an amount for interest on your capital, where we've agreed that I'm not going to get any interest on capital. And so you get all of that, and you get all of that, and out of the remainder, we've agreed that I should get just that tiny little bit there, and you get all of that. We can agree anything, so long as it's legal. Capital. The respective capital contributions of each of the partners. We need to agree, is this going to be fixed capital? Are we going to be allowed to draw against it? Or do we have to have a partners meeting if we're going to reduce our capital? This is the sort of thing that we need to agree. But we can agree. It's a matter of agreement. There's nothing is written down that says this is the way it will operate. Be careful. I was careful with the words I used there because we're coming to a little bit of Partnership Act 1890. G is goodwill. It's a common practice that partnerships will generate goodwill, the good name, the value attached to the good name of the firm. But it's also common that intangible non-current asset is not recognized within the partnership accounting records. So here are you and I, and we've built up and built up and built up the reputation of the firm higher and higher and higher. But where capital equals net assets, not included in those net assets is this intangible asset of goodwill. So capital doesn't equal net assets. In that situation, capital equals the carrying value of recognized net assets. But there is also the intangible, non-recognized element of goodwill. All right, well, how do you put a figure on this nebulous concept? And the answer is we need to agree. We need to agree on a formula by which we can compute a figure for goodwill so that in the event of my leaving the firm or in the event of me dying and another partner coming in that event, then there has to be some mathematical basis for the computation of how much of this intangible relates to my efforts. So that should be in the agreement. The basis of the computation calculation of goodwill. And finally, time, the time period for which the partnership is formed. Partnerships like any of the big four, any of the accountancy firms basically, partnerships like that don't tend to have a time period. And a partnership that does have a time period, for instance, will be you and I, and the time period will be until you qualify as a fully qualified accountant, and then our partnership will cease. So a time period may be built into the partnership agreement, and at the expiration of that time period, or on the occurrence of that event, that's the end of the partnership. If there is no partnership, and if there is no time period determined in the partnership agreement, then that type of firm is called a partnership at will. And a partnership at will, I'll write that down. I'm not going to write the whole partnership. A partnership at will. And a partnership at will is capable of being dissolved by any partner giving notice to all the other partners and saying, that's it, partnership is finished. And it's dissolved with effect from either the date of notice being given or with effect from the date where the notice specifies, with effect from the end of this month, our partnership is ended. Oh, then our partnership is ended with effect from the end of this month. So there we have typical contents within a partnership agreement. Accounts and audit, division of profits, drawings, the amount by which we may draw in advance of being credited with our share of capital. Whether we're going to have two separate accounts, a capital account and a current account, well, maybe others will, maybe have a loan account as well. Are we going to have a combined account like that, or are we going to have two separate ones? So that would be something to be agreed. We don't have to have two separate ones. We may agree just to have the one. Interest. Are we going to pay interest on capital contributions? Because if I'm putting in 100,000, you're only putting in 10,000, is it not fair that I should be given interest on my capital? We need to agree. Simple as that. Salaries. I do all the work. You sit at home with your feet up watching television. Should I get a salary? We can agree that I shall. But if we don't, then we haven't agreed. Capital, the respective capital contributions of each partner needs to be within the agreement. Goodwill and the basis of calculation for that goodwill needs to be agreed upon in advance or at the time of creation of the partnership. And the time period for which the partnership is to continue. And of course, if it is no time period, then that's a partnership at will. Now I'm going to finish that lecture now, and immediately next lecture we'll carry on with the 1890 Act, because the 1890 Act is relevant despite the fact that it's nearly 130 years old. It still is relevant to 21st century partnerships.